All right. What's going on, everybody? I want to go over some things on this video. And the reason why I'm going over these things is not to be rude, mean, or state certain things or to offend anybody. It's to kind of bring clarity because a lot of times when people talk about court procedures, most of the people who are giving you information in regards to court really don't understand court and they think they do. So if you see on the screen, I have something listed up here for a special appearance. Now, if you see this on the internet, a bunch of people will sit there and say, "Oh, you got to make a special appearance. You got to make a special appearance in court. If you make a special appearance in court, they'll say that, they don't have jurisdiction." Now, a lot of times when I do videos, or stuff, I'm doing videos to show you the technical aspect of things. I'm not doing videos to speak on vague, speculative stuff. I'm just showing you the technical aspect of stuff so you can kind of have an understanding. So if you go into court and you make a special appearance, because I've heard people say, "Oh, I go into court and I make a special appearance and woo 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 woo," and they're not understanding what a special appearance is. Okay, you have to understand what this is before you do it, and stop regurgitating stuff that you see on the internet. Stop just following people and research what you're doing and understand why you're doing it. Okay, a special appearance is a tool defendants can use to challenge the court's jurisdiction over them. Okay, if you're making a special appearance, the only thing you need to be talking about in court is two things: jurisdiction and venue. If you're not talking about these two things, it will be taken by the court that you are making a general appearance and you are engaging in contract or congress with the court. Okay, look, oh yeah, and I got to talk about my fragrance of the day, which is Naxos. Anywho, if a court does not have personal jurisdiction, what did I say? You must understand what personal jurisdiction. Or there are other errors like for service of process, many states allow defendants to challenge the lawsuit without submitting to the court's jurisdiction. Okay? So for you guys who just show up in court because you watch some YouTube videos and these YouTube videos told you to make a special appearance, there is a reason why you make a special appearance. Because a special appearance means that you are reserving your rights to challenge the court's jurisdiction, whether it's a violation of service, for service of process, if there is a issue with the venue of the court, an issue with parties or interests. That's what a special appearance is for. You don't just do a special appearance and then go into a general session of a court because then they're going to know that you're incompetent. Okay, normally, if a citizen were to make a general appearance, the jurisdiction issue would be waived. Okay, normally, if the citizen were to make a general appearance, the jurisdiction issue would be waived. So if you went into a prior court case and you appeared generally, you submitted to the court's jurisdiction, but you can still challenge that and walk it back also. Okay, for federal courts in some states, a defendant does not have to make a special appearance, but they are required to challenge the given error before addressing the actual claim itself as one would in a general appearance. Okay? Special appearance may also refer to other unique appearances by an attorney or an individual, such as an attorney appearing before being assigned to the case. Okay? This means before you agree in Congress or a contractual nexus, which means an implied contract with the court or the venue or the county, you must challenge the court's competency or its jurisdiction. Okay? When I made my video talking about the video with the law class, I'm showing you you really have to challenge competency. Competency s- Competency stops them from being able to issue a judgment. Okay, when you're challenging competency, it is separate from jurisdiction because for them to have a res judicata judgment, they have to be a court of a competent authority. Okay, if you challenge the competency, whether it's the competency of the evidence, the competency of the court, the competency of the statements placed in the court, or any of these things, there's things that you have to challenge before you go into court. But if you're going to challenge them, that's after if you do a special appearance and challenge the personal jurisdiction of the court. Okay, I can't say everything to do with court because it's too much. People who just tell you to challenge jurisdiction don't even know how, they don't understand how to challenge jurisdiction eloquently themselves. There's elements that you have to challenge, and that's why you have to read your state law. It'll show you how to get out of everything because the people who bring the cause or bring the action have to bring the remedy. That's why all of your state will show you civil, whether you can look it up through federal civil procedure or state civil procedure. It will show you all of these things. So you don't have to speculate and look at YouTube videos and hope that you're getting proper information. Okay, because I fell for this shit too. Going into court using other people's documents and you not knowing what the hell you're doing. You have to understand what you're doing because these people ain't playing with you. You go in there playing around all you want to. Okay, a general appearance. Okay, this is a general appearance. And that's why you need to understand that court has to deal with banking. It's not what you think it is. You're not even supposed to appear in the chambers of the judge. You're not even supposed to appear in the courtroom, but you do it because most people are ignorant of the court. So look, I've done it myself. I was a dumbass too, walking in court, going into a general session like a dumbass. I didn't know this. And even when you watch it on the internet, people don't explain it like I'm explaining it. So, look, a general appearance is made when a party first comes into court and appears in the case. Okay? So when you initially have a court case, what happens is the plaintiff is entitled to one evidentiary hearing. So they have to have one evidentiary hearing. That's what they're entitled to. Any frequent hearings after that is because the court has taken that you have made a general appearance and you have submitted to the court. Why? Because you have not raised any issues challenging jurisdiction or proving that you settled the case prior to any case conferences, etc. Okay. I hope y'all understand this because people on the internet teaching these YouTube lawyers are not teaching you nuance. You must know nuance. Do not listen to a video and not understand that there is some nuance behind it. Okay, some states follow common law and do not consider a general appearance made when a party comes into a court purely to challenge a court's what? Personal jurisdiction over the defendant. How come everybody used to tell you challenge the subject matter jurisdiction? You had to challenge the personal jurisdiction first. Because if you challenge the personal jurisdiction and you're able to get the case thrown out, then they don't have subject matter jurisdiction. Subject matter jurisdiction allows you to redefend any action. Now, yeah, in some instances, you can challenge the personal jurisdiction again, even if you came in the court because there wasn't service. Just because you go into service, they think that you're waiving jurisdiction because you never objected or you never challenged it in that court. Okay, challenge the court's personal jurisdiction over the defendant. Okay, this is known as a special appearance. Okay, let me say that again. Some states follow a common law and do not consider a general appearance made when a party comes into court purely to challenge the court's personal jurisdiction over the defendant. This is instead known as a special appearance. Okay, so you don't always have to say, I'm here by special appearance, but it's good to do it. Okay, you can always challenge a court's personal jurisdiction and you can always challenge a court's subject matter jurisdiction. And if a court says that they have personal jurisdiction, I still got some fire for that too. But a lot of times, what people do is you listen to stuff and you never do your own research. Always do your own research because remember, if somebody tells you to do something and you go to jail, it's really not their fault, it's yours. So the distinction is notable because in these states, a general appearance is considered consent by the defendant to personal jurisdiction and thereby waives the defendant's rights to challenge personal jurisdiction or service process. However, Rule 12b2 of Federal Rules of Civil Procedure abolished the distinction between general and special appearances in federal courts, and many states have adopted this modification. Okay, so it abolished this perception. Okay, so that's why when people tell you you have to send a notice of special appearance, when you appear in the court and you're appearing to challenge the jurisdiction of the court, you have to either make a special appearance or send a notice that you're appearing that you're challenging the venue, etc. Okay, a general appearance typically is made the first time an attorney appears in court as an authorized representative of a client. However, any act by a party that recognizes the pending action as a valid and proper can be considered a general appearance. Moreover, a general appearance any can include an attempt by a party to seek any affirmative action from the court or to seek the court's judgment on a question beyond that of the jurisdiction. For example, opposing a motion on its merits is considered a general appearance. What did I say again? Opposing a motion on its merits is considered a general appearance. So when people ask me, why do I say don't go into court challenging things and until you know what you're doing? It's because once you challenge a motion on its merits, it is considered a general appearance. Okay. So look at the merits. See, these are look these terms up in law. And then when you understand the terms in law, you will understand things better. You should have, if you see how many tabs I have open, I probably have anywhere from 600 to 700 tabs open because that's how much research I do. You have to have tabs open on your stuff like that, or you have to keep bookmarking and parking lotting this stuff because if you don't do it, you're not going to learn, and you're going to just take people's information and then run on that, and then when it don't work out, you're going to blame them for it when it's really you should blame because you never put in the work. You can't get mad because you won't shoot 700 shots a day and you're not as good as LeBron James, or you're not as good as Giannis, or you're not good as these other people in the game. You ain't shooting no shots. So if you don't shoot no shots, you don't put in the work, you don't get the results. That's just what it is. If you think somebody's just gonna drop the answer on your lap, you out your damn mind. Okay, on the merits. The phrase on the merits refers to a case decision rests upon the law as it is applied to the particular evidence and the facts presented in the case. This is in opposition to the case whose decision rests upon procedural grounds. Okay, so this means once all of the facts is laid out on the table, the judge has to take it because due to the preponderance of the evidence, due to the preponderance of the facts placed on the record and unobjected, the court must issue a judgment. That's why when I tell people, I say you don't have to go into court and challenge jurisdiction because you don't. You have to you have to be a tactician in court. Challenging jurisdiction sometimes can show that you're incompetent because sometimes you may need the court to finalize a contract between you and a so-called aggrieved party or a party that's in disagreement with you. Okay, the distinction between decisions that rest on the merits rather than the procedural ground is important because a decision on the merits is considered final and is thus bound by res judicata. That means that once you have a decision, nobody can come back on it. Okay, once you have a decision, that is the contract because technically you're in court to make a contract. Okay, if a decision is bound by res judicata, the parties involved in the case may not later raise those same claims in a subsequent case. So if it's ruled on, that's why an attorney will usually tell you don't bring up more than one claim in one case. That's why I try to keep when I do my motions, I try to keep my motions simple. Maybe 2, 3 claims at best, but you're really supposed to only bring up 1 claim. And if you bring up 1 claim, just stick to that claim, because if they dismiss it and then it's considered res judicata, you could bring up another claim. So you know what I'm saying? So people don't understand you have to be a tactician in court. You can't just go in there, challenge the jurisdiction. They're gonna be like, on what ground? Instead, a party that disagrees with the decision must appeal. See, you have to appeal a res judicata ruling. You can appeal it because you can challenge the finality of the ruling. The ruling. But see, I ain't getting into all this law stuff. See, I had to go through court and learn this the hard way. Luckily, y'all have me available to show you how not to go through this the hard way. The decision filed a motion for a new trial, which is a trial de novo, okay? Or file a motion to reconsider, which is something that you can do, okay? Decisions that do not rest on the merits, however, are not bound by res judicata, okay? Because the claims were not properly heard. Thus, these claims may be brought forth in a subsequent case, excluding dismissals due to failure to state a claim, okay? So look this stuff up. Click these links. Go on this website and have fun with it. Start reading court cases. For most of y'all don't want to learn court procedure until y'all in trouble. People don't want to learn court procedure to somebody about to steal their house. If you learn this ahead of time, they can't steal your house. I had to learn all of this the hard way. You don't have to do it the hard way. You have to be a researching fool. You gotta love this stuff, man. Okay, so we read on the merits. Okay, it's considered a general appearance. The actual intent of the party in making an appearance does not affect whether the court will consider it to be a general appearance. Jurisdiction may specify certain exceptions as to what constitutes a general appearance. Each jurisdiction has a statutorily prescribed time period in which a general appearance must be made after the service of process is complete. If a general appearance is not made by the defendant within this time period, the plaintiff will receive a default judgment. See, if a general appearance is not made, this is why most people go into court and they say, oh, the court is so corrupt. Oh, child support is so corrupt. Because, man, when you make a general appearance, right? So when you go into court, because you're listening to YouTube people, and a lot of them don't read, if you go into court, you don't make a general appearance, they're going to still issue a default judgment. That doesn't mean you can't vacate the default judgment. It just means that you haven't appeared. The court's just not going to sit here and wait and play games with you, because you would be mad if they did it to you on the other end. So when you go into court, this is why some people just don't understand the strategy of court. Don't do anything to the court that you wouldn't want done to you. What happens if you have to sue somebody and then they play the games? Oh, nope, nope, I'm not coming to court for this. Nope, nope, nope. That's why the court issues a default judgment. A default judgment can be vacated on numerous things, and I might bring that up also. Each defendant must make a general appearance. After an attorney has appeared in court on behalf of the client, the attorney is responsible for all future appearances in court, unless there is a substitution of attorney or a court order releases the attorney. Okay, so now you understand. So the people who are telling you to do special appearances, you have to learn the nuances about doing a special appearance in court. You can't just go into court, say, I'm here on special appearance, and you done already been in the court 6 damn times, 7 times in a court case. And if they throw your ass in jail for that shit, it's because you're not paying attention. You know, just like I said, jail has to deal with contract. The only way that the court or the state can put you into jail is there is some contract binding you to a specific performance, like parole. Otherwise, they cannot put you in jail. That's why I said that when I did my child support video, I told you that the constitutionality of child support is, I mean, the part where child support is not constitutional is the part of the punishment. So if you learn to read, you'll start understanding this more. All right.